Hi, Ross Runkel here to talk about New Prime versus Oliveira, a case pending in the United States Supreme Court, argued on October 3rd. So we've got an interstate truck driver. All of his documents say he's an independent contractor. He thinks he's been misclassified, should be an employee, so he's brought a suit for unpaid wages and so on. Now, the contract he signed has an arbitration clause, and that arbitration clause has a clause within it delegating arbitrability questions to the arbitrator. So, question number one before the court: does the Federal Arbitration Act apply? Now, FAA Section 1 has an exemption for contracts of employment of seamen, railway employees, or any other class of workers engaged in interstate commerce. Contracts of employment. Now, employees in this limited category are exempt from the statute. So the employer says, fine, he's not an employee, so the FAA applies, so the case should go to arbitration. The driver and the First Circuit say, look, contracts of employment includes any contract to do work. So it does include independent contractors, so the FAA does not apply, and the case can stay in court. All right, so who decides whether the FAA applies? The employer says, well, that's a question that should be decided by the arbitrator, because the contract has this delegation clause that says arbitrability is to be resolved by arbitration. The employee says, oh, wait, Nelly, whether the FAA applies or not is a court question and has to be decided first. So when this case was at the First Circuit, they said first, whether or not the FAA applies is a threshold question for the court to decide. So that's part of the dispute. The other thing the First Circuit said was an independent contractor has a contract of employment, so the FAA does not apply, so the case stays in court. It's all up to the Supreme Court, and we'll see a decision in 2019. Thank you for watching.